A challenging year which witnessed the battered image of the judiciary, technicalities resulting in injustice in some cases, and poor funding of judicial officers, among others, is how some senior legal practitioners have described the year 2023. On the show today, we hear from 3 senior advocates of Nigeria who also give suggestions for the task ahead this 2024 for the judiciary, stakeholders in the sector, and even government. We also have a recap of some of the top legal stories in the news. Happy New Year, everyone, and welcome to the program. I'm Shola Shieli. The start of a new year provides a good opportunity to take stock of the past year and to set an agenda for the new year. And that's what we will do today on this episode of the program. We have the views of 3 senior advocates, Alex Izinyo, Jibrin Okutepa, and Ahmed Raji. First, we get their views on the challenges facing the judicial sector, and then the task ahead for stakeholders and even the government.
2023, I must say, it was a challenging time for the judiciary. A challenging time because apart from its constitutional role and functions, the added responsibility of the election year. So that was what made it challenging. And then don't forget, we're transiting from one political era to the other. What I mean by that is that there was a fresh election where you have people, new heads of states, president vying. So it was challenging because there were too many expectations. And therefore, the courts were saddled. The regular courts, many of the judges were picked up to function as members and judges of the election tribunal, flowing from the election, that is the House of Assembly, the governorship, National Assembly, and presidential. So the same goes for the Court of Appeal. There were panels set up to hear appeal coming from the Houses of Assembly and National Assembly elections. And before then, there were also pre-election matters. These were matters that have to emanate from the Federal High Court or the State High Court, as the case may be, to the Court of Appeal and to the Supreme Court. So it was enormous. It was challenging. But however, no matter how daunting it was, I must say the judiciary did very well. Because assuming they didn't live up to the challenges, it's a different story. I am not aware of any singular matter where the cases has lapsed, because constitutionally they were expected to be conducted within the time frame. None. Some within 6 months, appeal 2 months, Court of Appeal and Supreme Court, including pre-election matters. So there was no case, I'm not aware of anywhere, one, because they couldn't finish up in time, it was lapse or any laxity. So I must commend them that they did very well. Yes, there are bound to be some challenges and sentiments being raised. Let me pose a question. If all litigants or plaintiffs or petitioners go to the court and all wins, have you ever seen it? It's not possible. So there must be a loser. So, but we've come to a state where people don't take losing in good faith. And then the next thing is to see some callous write-ups. The reason is that some of them are not based on facts and law. Majority haven't read the judgment to see the thinking. I've done some, I won some, I lost some, and the reasons are there. So you find it very absurd. Some of our colleagues in the papers and the TV, they write. Let us not lend our credence to say it. Yes, I'm not saying that there are no few 1 or 2 areas where there are challenges of miscarriage of justice or otherwise. But to me, that is infinitesimal compared to the majority of good decisions that have been given. So to my mind, I think fair and square, if you say arithmetically or mathematically, to score them, maybe 80% is an A in an exam. That's my view. The 2024, we are here, God sparing our life. It's no longer election year, except some of those few election matters from the states. My view is that, for example, the Supreme Court, now we have, God helping us to have a full court, quorum. There should be discongestions. What I mean is that there will be more hands now. So the decisions, the durations of hearing appeals will now be reduced. Instead of looking at the Supreme Court, any matter that comes to the Supreme Court, you cannot talk about less than 6 or 7 years before you get right for hearing. So let us do some weeding, some, call it exercises that may be, whether it's criminal or civil clearance, to deal with this, so that we can make way for speedy and expeditious dispensation of justice as the cases come. So those are those cases from the Supreme Court. Same things go for the Court of Appeal and all the courts. The essence is that when justice is denied, the efficacy becomes meaningless. It becomes pyrrhic. And don't forget, particularly in civil matters where you have now, our naira is dwindling. You're asking for debt. You're asking for some recovery. At the end of the day, the monetary value of what you're asking for, you can't compare it with the previous time when this matter started. So my view is that the dynamic nature of economically, the judiciary should come in headlong to also assist, so that that justice will be even and balanced economically alongside with quick disposition of matters. That's the simple agenda, and all stakeholders must be on deck here, whether it's the legal practitioner or the judges or the criminal aspect, all the security agencies, the EFCC, the ICPC, the police, the SSS, the NDLA. All hands must be on deck so that we can make progress. The society is dynamic. As we grow and we improve and we increase, there are bound to be more frictions. There are bound to be increase in crime. There are bound to be more in civil matters and frictions. So there have to be a procedure where we must adjust and adapt and anticipate this. Otherwise, we will be at the running end, at the backstage at all time.
The judiciary will need to redeem itself. And like I keep saying, apart from the judiciary, the legal profession needs also to redeem itself from the battered image that it has put itself. And when you listen to some of their lordships that have retired, you begin to know that all is not well. So it must revisit some of its decisions that seems to have put roadblocks on the wheel of justice and seem to have encouraged Nigerian politicians to engage in reckless abandon and undermine the sovereignty of the people. Decisions such as you are insisting that you must front-load a witness statement of a supreme witness before the election petition is filed. It's a decision that the Supreme Court must revisit if it's not going to be accused of aiding and abetting the destruction of democracy in Nigeria. Because if that is not reviewed, it means that in 2027 or some of the other off-season election, or those exhibit or those evidence, because we have now had a decision that says you must front-load all your witness statements on oath before you file petition within 21 days. I do not think that that is justice. So the Supreme Court must revisit it. 2, I think time has come that the judiciary itself must also think of giving justice in judgment, rather than the multiplicities of judgments that are being dished out, that when you look at critically at that justice that comes, judgment that comes out of court, a lot of them contains injustice. Because once the decision is not fair, a decision does not represent the reality on the ground, the reality that everybody knows, the reality that market men and women know, the reality that the artisans know, and you produce documents, and then we begin to employ what they call sui generis rules of construction or principles of law in a negative form. Because I think that if we want to use the concept of sui generis in electoral jurisprudence, it should be in favor of the courts admitting documents and relax some of the rules of technicalities that cause them to close eyes to otherwise documents that are available that shows infraction. But you come and hear such principles that you have a document, you must demonstrate it. How do you demonstrate what is written in English language? The official language of Nigerian courts is English language. The lingua franca of Nigerian courts is English language. And so if a document is written in English language, you see mutilation, you see cancellations, you see a person struggling to make addition. You go, you produce a result from polling units. When you put them together, the results are less than the total number of results that have been given to the supposed winner of election. And you are still telling me that in the face of Form E8As that shows otherwise, I must still go and produce somebody from polling unit by polling unit. Where do you have that time, given that you have 180 days to prove and judgment deliver an election petition? So the concept of sui generis that have been negatively interpreted by our courts to affect the rights of supposed loser of election petition must be revisited in 2024 and beyond. We must go back to the good golden olden days where the Supreme Court itself says that if there is anywhere that technicality should not rear its head, it should be in election petition. The reason being, as their lordship reason rightly in my view, that in deciding election petition matter, you are not dealing with just the right of the parties before the court, but you are also dealing with the rights of the electorate and the Nigerian people who had exercised their fundamental right to make choices of who to govern them. So we have decided to employ this concept of sui generis negatively in my estimation, and I think that they need to revisit it so that it be employed in a positive way that enhances democracy. So the judiciary and the legal profession must note that Nigerians are watching, and like I have said, I've written, if we are not careful, we may not be able to escape the mob action of the public who sees every one of us as part and parcel of Nigerian problem. And may the day never come when a judge sitting or a lawyer passing on the road will be stoned because of what we do. And so we must go back to the priesthood that is our calling. Lawyers and judges are priests. And so we must go back to the priesthood where we must be husband and wife of one, husband of one woman and wife of one husband, so that, and I use that figuratively, so that we don't engage in polygamous adulteration of justice in Nigeria and then sitting there thinking that we can give equal love to all the parties. No, it cannot happen. So we must purify our hearts, must purify ourselves, we must go back to the ethics of the profession and give undiluted justice to our people in 2024 and beyond. And once we start giving the right decisions, right judgments, we will discover very shortly that investments will overcome will come to Nigeria's economy, and the economy will become so booming that unemployment will be a thing of the past.
Welcome back. Senior Advocate of Nigeria, Ahmed Raji, also shares his views next.
Other challenges range from funding and poor remuneration. Our judicial officers are not being well paid, although I'm aware this current government is doing something about that, for which we have to commend them, most especially the President and the Attorney General. We have to commend them for looking into the poor remuneration of the judges. And when I say judges, not just the Supreme Court justices, I'm talking of the Court of Appeal judges, High Court judges, National Industrial Court, Federal High Court, all of them. The pay is bad, very bad. Perhaps I should also mention the fact that the highest court of the land, the jurisdiction, should be revisited. Not all cases should end up in the highest court of the land. I do not think the highest court of the land is meant to be taking all manners of appeals. Some appeals should die at the Court of Appeal. At worst, all appeals to the Supreme Court should be with the leave of the Supreme Court, and not a situation where everybody, all manners of appeal, will now end up there, and then the docket is always full. Then people are struggling for dates, and in the process, all sorts of untoward attitude, untoward actions by some staff of the court and what have you. So I believe there is a need to streamline the jurisdiction of the Supreme Court in a way that it is not all appeals that to be allowed to go there. Some matters, or most matters, the final court should be the Court of Appeal, and not that you have a small land matter from Ogoja or something from Adoikiti, or maybe from somewhere in Kukawa, or Brennan Magaji, ending up in the Supreme Court, traveling from Magistrate Court up to Supreme Court. Why? That is not where the Supreme Court is made. So, and that is why when you look at their conditions, you cannot but pity them. Time has come for the court itself, especially the Supreme Court, to consider taking some motions, especially non-contentious ones, in chambers, so as to reduce the time people dress up, wasting them in coming to the court. And I'm not opposing, and all this should be taken care of in chambers. without coming to the open. The rules should be tinkered with in such a way as to allow that and reduce the congestion in their dockets. And even contentious ones, motions, they can settle it based on after all, when you go there now, you hardly have the time to adumbrate because of the sheer number of cases. I don't blame them for that, because the cases are too many. So if you have to adumbrate for 3-4 hours, how many cases can they hear? So motions should be a matter for chambers. Substantive appeal should be a matter for open court. That is my humble opinion.
And just before we go, a quick recap of some of the top legal stories in the news.
We begin with the report that the Nigerian Bar Association has asked President Bola Tinubu to show more commitment and prioritize the security of lives and property of Nigerians. In a New Year message signed by the President of the Nigerian Bar Association, Senior Advocate of Nigeria Yakubu Mekiao, the NBA said government, through the armed forces and other security agencies, must ensure that no part of the Nigerian territory is left ungoverned and under the control of criminal elements by whatever name so called. The NBA president also condemned the December 24th attacks on villages in Plateau State by terrorists which claimed the lives of over 200 residents. He particularly blamed the failure of intelligence for the Plateau killings. Mr. Mekiao said the incidents were inexcusable and unacceptable. Staying with the NBA, the last has not been heard of the suit between the association and the former Minister of Women Affairs and Social Development, Pauline Tallen, as she has filed 13 grounds before the Court of Appeal, Abuja Division, to challenge the judgment of the Federal Capital Territory High Court in respect of the kangaroo public comments she made over a Federal High Court decision. The 22-page notice of appeal was filed on her behalf by the law firm of Senior Advocate of Nigeria, Judiciary Gadzama. In the notice of appeal dated December 29, 2023 and filed January 3, 2024, the former minister challenged the whole decision of Justice Peter Kekemeke delivered on December 18th in favor of the incorporated trustees of the Nigerian Bar Association. In that judgment, the court declared that the said statement of Dame Pauline Tallen was unconstitutional, careless, reckless, disparaging, a call to disobey the judgment of court and therefore contemptuous of the Federal High Court of Nigeria. But in her appeal, Tallen urged the court, among other reliefs, to set aside the judgment and dismiss the suit. She maintained that the trial court erred in law and occasioned a miscarriage of justice in determining her preliminary objection on the competence of the respondent's affidavit, locus standi, propriety of the suit, and credible evidence. In Lagos, Mr. Olumide Shonupe, a legal practitioner, has been hospitalized after allegedly being detained for 2 nights at the Mashalashi police station while seeking bail for his client. The 36-year-old lawyer, who was locked up with his client, a carpenter, over a breach of contractual obligation, was rushed to the hospital on January 1st when his health deteriorated upon release from custody. Olumide claims he was manhandled and forcibly stripped before being thrown in the cell for insisting the matter was civil rather than criminal. CCTV footage is said to show police officers dragging him to the cells while removing his clothes. While the Lagos Police Command has confirmed the incident but accused the lawyer of acting without decorum, the NBA has said it will investigate the matter. Staying in Lagos, the Federal High Court sitting in Ikoyi has awarded the sum of 500 million naira as general and aggravated damages against the Nigerian Customs Service for illegally sealing up the business premises of members of the registered trustees of auto dealers in Lagos. Justice Abimbola Awogboro, in a judgment, held that the sealing of the car marts of the plaintiff's members was unlawful and arbitrary, as there was no justification for the illegal act. The judge ordered the Nigerian Customs Service to immediately unseal the car marts it unlawfully sealed across the country. The auto dealers had dragged the Nigerian Customs Service Board, the chairman of the board and the Controller General, Nigerian Customs, before the court in 2019 after over 434 car marts and shops belonging to the plaintiff and its members in Lagos were sealed up on the suspicion that the vehicles on the premises were smuggled or under-assessed during clearance at the ports. But in their suit, the registered trustees of auto dealers in Lagos, through their lawyer Monday Ubani, accused the Customs Service of harassment, illegality, extortion, irresponsibility, unprecedented impunity and abuse of power. Moving on to Kano State, the Federal High Court sitting in Abuja has given the Kano State government a 7-day ultimatum to show cause why the ex-parte orders sought by the 44 local government areas of the state should not be granted. The Association of Local Governments of Nigeria Kano State Chapter had in the suit asked the court to stop the state government, the state's Attorney General and Commissioner for Justice, and the State Accountant General from disbursing and spending the funds and allocations belonging to the local government areas in the Kano State Joint Local Account, pending the determination of the plaintiff's substantive suit. And we round off with the story of the temporary relocation of former Sierra Leonean President Ernest Bai Koroma to Nigeria by the Economic Community of West African States ECOWAS over allegations of masterminding a failed coup to overthrow the current government in November 2023. The temporary accommodation was arranged as part of an agreement to drop all charges against Mr. Koroma, whom the Sierra Leonean government accused of treason and 4 other offences in a high court on Wednesday, January the 3rd. He was released on bail but placed on house arrest at his residence in Freetown while the matter was adjourned till January the 17th. But the government said it was willing to drop all the charges if Mr. Koroma vacated the country tentatively. The former president has accepted the offer to be hosted in Nigeria.
And this is where we adjourn proceedings for today. Do remember to check out the Channels TV website for a replay of this episode of the program, as well as past episodes. Please also send in any feedback via our social media handles. I'm Shola Sheyele. Thank you for watching, and see you next week.